ultimately, this is the written judgment that corresponds to the court's decision that was made prior to sentencing on the date that Markus was sentenced. So this, as of right now, is exactly what we expected. It just explains the court's decision and actually puts it in writing versus the court's oral pronouncement where he denied our motion for a new trial. So again, it's not unexpected at this time. We anticipated that we'd be getting a written order, and he had already decided on these issues, but like I said, it corresponds and makes the record complete on the issues. As far as reaction at this time, the reaction is the same as at the time of the court's decision prior to sentencing. The issues that are incorporated in the motion for a new trial, specifically regarding our motions to change venue on prejudicial pretrial publicity, as well as our objections to the use of force instructions where the jury, we believe, should not have been instructed on justifiable use of force in defense of a person. Those are going to be two significant issues that we'll be addressing on appeal. So at this time, there's no immediate reaction that's any different than, our feelings prior to sentencing and after sentencing that, we believe strongly that there are a couple legal issues here that are going to be addressed by the Supreme Court ultimately. But again, this opinion and order just corresponds to the motions that were filed prior to Markus' sentencing.
Sure. Okay. So, what is the procedure? Because I hate to say, but I must let you know my ignorance of how this whole thing works. What is the procedure of applying to the Supreme Court, and when will you know if they decide to hear your case?
So, in Montana, we don't have an intermediary appellate court. So essentially the Montana Supreme Court hears all of our appeals. We don't necessarily have to apply to that extent. We just need to file a notice of appeal that we do intend to appeal, and it's a criminal case, so it has to be filed within 60 days of the written judgment. And then following that, we have some time periods that we have to actually get our brief and any other corresponding documents that need to be filed to the Supreme Court for its consideration. And depending on, I guess, how long it takes us to get the record complete and to get transcripts of proceedings, that may change how long it's going to take us to file the actual briefs or our actual brief. But ultimately, we have 60 days to file our initial notice of appeal. And then the Supreme Court will, at some point down the road, actually consider our appeal.
Well, now, Nate, does that mean you have 60 days from today when they release this on paper, or 60 days from the actual sentencing?
Well, it's 60 days from the time that the written judgment corresponding to sentencing was issued by the court. So essentially, this opinion and order regarding the motion for a new trial, this is something that the issues here will be appealed, but it's 60 days from the time of the written judgment, and that occurred actually, we received that on the date that Markus was sentenced.
All right, so your deadline to file that appeal with the Supreme Court is rapidly approaching that.
Well, not to file the actual appeal itself. The deadline to file our notice of appeal is approaching.
I see, okay.
And once we file our notice of appeal, that triggers the process. And then after that, you have, generally speaking, you'll have 30 days to file your brief. However, in cases like this where there are going to be a lot of issues that are being briefed, it's not uncommon for time extensions to be applied for and ultimately, for those dates to be pushed out. But the first hard deadline is getting the notice filed, and then after that, we have time to actually file our brief, and then, the state will have similarly an amount of time to file its response, and that'll be followed by our reply. So again, until there's actually anything, dispositive on the appeal, it may be a while. But again, the process of, researching and writing and all that stuff, that basically began prior to Markus' sentencing, where, we're looking at these issues and moving forward with them and to make sure they're adequately briefed. And again, we we think that, while we respect the court's decisions, we think that we have some legitimate issues for the Supreme Court to consider, some of which I think are actually going to be issues of first impression for this court, where potentially it hasn't directly considered them before.